Hi there, my name is Alex Baddock, and this is the Hamilton Education Law Program. Today we're talking about special education. What we're really trying to do in this session is to kind of demystify what special education is, get rid of those preconceived notions, and really encourage parents to view special education as a useful tool in their child's success. So when we talk about special education, we're really talking about the barriers that many students across Ontario face in many different circumstances. So for parents, this information is really about empowerment and how you can make this knowledge useful for your child and their success. So we really are trying to break down the stigma about special education in this session. I want you to think about what special education means to you. And I want you to really think about what that looks like to you. What we want to do is remove the stigma and give further understanding of special education and how students can actually benefit from it. And then we want to also give an understanding to the process and mechanisms surrounding special education. So 1 in 10 students in Ontario and Ontario elementary and secondary schools are in special education programming. That's about 290,000 students. What we really need to understand as a principle for special education is that all children should have access to high quality education. So whatever you believe special education was, hopefully it aligns with that understanding. So special education comes back to human rights and the idea that there are inherent rights that all people should have. In our society, there's a broad obligation to not discriminate on the basis of a prohibited ground. Now that includes race, gender, and especially disabilities. So the concept behind human rights in education and special education is quite simple. It's that all students should have access to meaningful education. And meaningful education is a barrier-free education. That means there should be no circumstances that a child has that should prevent them from achieving and reaching and getting a high-quality education. So when we talk about special education and human rights, we have to talk about the broader obligation to accommodate persons with disabilities. And what we do is focus on the interests of the child in circumstances like this. It's a very nuanced point, but best interests may vary and may differ from situation to situation. It's a specialized process that special education undergoes to provide that best interest for the child. Special education processes do not exhaust the school obligations under the human rights, however. Human rights is much broader, so schools may have to meet other conditions for accommodations under the special education provisions of the Education Act. So we're going to talk a little bit more about the process itself that the special education process in schools looks like. But I just wanted to reiterate that the human rights threshold is very different from that of the special education mechanisms. They're defined differently. Some disabilities may trigger human rights protections where other special education mechanisms may not. For example, some students may have a broken arm, for example. That doesn't necessarily trigger an obligation underneath the Human Rights Code. However, it does trigger an obligation under the special education provisions. And you can see this quite clearly when you think about, for example, if I were to break my dominant hand and I had to take notes in class and write exams, I would be encountering a barrier to my education. The school's obligation then would be to provide an accommodation to ensure that that barrier was not preventing my meaningful access to education. So we have to remember that there are several principles that underlie special education in Ontario. The first is that students with a disability or other conditions that affect their ability to learn have a right to special education. Now that's an important thing to note. The right creates an obligation on the schools to provide that accommodation for a student. Now the second is that publicly funded school boards must provide special education programs and services. Now, this furthers that obligation of the schools because it now creates an obligation for school boards to have in place these programs and services that are accessible to families. And the third is that there must be a defined process for the identification and placement of exceptional students. And we'll talk about exceptional students in just a moment, but the defined process is crucial to being able to support students. What the identification and placement process does is it looks at the individual aspects of a child's circumstances and really defines what it is that is creating a barrier to that meaningful education. So special education really does a couple of things. It describes the supports and the programs for students who need different teaching methods or special equipment to allow them to succeed. Students with a legal right to special education are identified as exceptional. Exceptionalities refer to the need for different teaching methods or resources to allow them to succeed in school. Now remember, all students have a right to meaningful education. Exceptionalities can create barriers when education is provided in the typical way that schools give them. And that's why there's this defined process to identify what additional supports a school may need to provide to ensure that that barrier is no longer significant. So the next and most probably obvious question is, when does this special education need arise? And the thing is that it's triggered when the identification of a student is raised. Now, boards have an obligation to act on information suggesting that students may be exceptional. However, that obligation is not limited to identified students because of the broader human rights obligations. So that means that you don't necessarily have to go through the identification placement committee to get that accommodation because of the broader human rights obligation of schools. So the identification placement process committee is actually just, it is a committee, but it's also used to describe the process. And this process essentially states the students' strengths and their needs. It also looks at the type of exceptionality, the type of classroom placement the student should be in, and what further accommodations would be necessary. Now, the identification placement process committee is referred to determine the exceptionalities of a student. The committee members are usually parents, classroom teachers, special education teachers, and administrators. And the intention is for it to be informal, but families may have representatives with them to better support their understanding and their child's needs in those contexts. So exceptionalities are a unique term to describe the needs of a student. The term exceptional means that the student cannot be successful in a regular or typical program delivered by a classroom teacher without support. So areas in which students can be exceptional include behavior, for example, which means the student displays behaviors that can interfere with the learning environment. And for example, these include conduct disorders, anxiety, such as ODD and ADD. Physical exceptionalities include the challenges that students may have physically that impair their ability to be successful in the classroom. And this, for example, this might be a visual impairment. The next is the intellectual exceptionalities. And this is where students are identified as possessing mild intellectual disability, or they've been identified as having a developmental disability. A student may also be identified as gifted underneath intellectual exceptionalities. For communication exceptionalities, the student may be, and this may take different forms, such as being recognized as autistic, suffering from different impairments, such as language impairments, speech impairments, being hard of hearing, and having a general learning disability. I use the term suffering, but that's incorrect. The language that is used when it comes to special education and needs of special education is significant to really understanding how these communities manage these different issues. When we use language like special education, we have to put the person first as well. And it's a constant recognition and being conscious of your use of language when it comes to this. That's also important as a need for students and the way that they are treated, the way that they are supported. So being very cognizant of the language you use when it comes to this is incredibly important. So multiple exceptionalities include when there are a mix of one of those four that I just described. The student may have one or more exceptionality that creates a barrier to their learning, and so the placements that are necessary or the accommodations that are necessary will need to reflect that. Something we should note as well is that you don't necessarily need to be identified with an exceptionality to have an indicator for a learning disability. There doesn't necessarily need to be a formal testing for a student to be supported, but we will talk about that shortly. Once a student is identified in terms of one of these categories, their placements in their learning environment is determined by the committee. And we talked about the committee very briefly, but upon receiving a written request from a student, parent, or guardian, this is where a principal refers a family to the IPRC. And that's, again, the placement committee that we had discussed. It's both the process and the committee. And within 15 days, they should get a response. And within 10 days of notice, they should get a hearing. So parents and students over 16 have a right to attend an IPRC. Now, when it comes to the placements, these are the different ways in which those people on the committee are able to identify and direct the supports that are needed for a student. Now, these placements take different forms, such as a regular classroom, and I keep using regular because language really matters. A regular class would just be akin to a typical classroom that students are in on a day-to-day basis. Now, a regular class with indirect support.
It's 12 o'clock.
A regular class with resource assistance. A regular class with withdrawal assistance. A special education class, which would be the alternative to the regular class with partial integration, and special education class with full-time integration are the available placements for students. Now, when it comes to determining these placements, they operate on principles established by the Supreme Court. There's a need to consider the child's views and parents' views in matters when it comes to determining the placement. But their views are not determinative, especially if it's not in the child's best interest. Now, what that means is, although a parent and the child's views may be significant, it may not necessarily align with this test that requires the best interest for the child. So when we think about the best interest for a child, the committee must look at individual needs of children and as well as the individual needs that must be accommodated. Remember, the goal is to ensure that meaningful access to education is available. And for that reason, the integration into a typical and regular classroom may be the norm, but it's not the presumption. And that's because there are different needs for different children. So the best interest of the child will guide what decisions the committee will end up making. So whatever the committee ends up determining is not concrete. The role of an advocate, especially a parent or guardian, is to broker the middle ground. And the parent may have some extreme position, a school may share another alternative extreme position, and they don't actually need to be extremes, but the point is there may be differing views of parent, child, and/or the school. An advocate or a third party, or someone who acknowledges that there are differing views amongst both sides will have to acknowledge that there may be a middle ground that is necessary in the circumstances. So when it comes to the programs and services offered by IPRC, like I said, there are placements that are available, but they also come with IEPs, which are referred to as individual education plans in Ontario's education system. So each student who is identified as exceptional must be provided with the appropriate programs and services. An IEP contains specific learning expectations and the school outlines and shares to address them. It's important to remember, though, that non-identified students without exceptionalities or without identified exceptionalities can also have IEPs. And this is really where the significance about the understanding of special education and using it as a tool for supporting student success is important. An individual education plan, like I mentioned, is simply the teacher cultivating the appropriate programs and services needed to support a student to make sure that meaningful access is still possible. The truth be told, all students should be treated in this way, but the reality is we need to make sure that parents are communicating with teachers if a need arises. So when it comes to the idea of an IEP, we recognize it's a working document. It's an evolving document. It recognizes the strengths and needs of a children as well. And those strengths and needs evolve over time. And so will that documents containing the services and programs that are provided to students. Students who are 14 years and older must also have included in them a plan for transition into the high school world. So parents and students over 16 must be consulted about an IEP and receive a copy within 30 days of a placement in a special education program. Of note to parents is that an IEP should regularly be updated, and you should be consulted on it as well. So if you are able to ensure that your child has a support through an IEP, make sure that you're regularly communicating with those teachers. So just a little bit more details about an IEP. It should contain specific learning expectation and a school's outline of educational services to address them. The IEP also explains the student's progress and should be reviewed. And for students 14 years and older, like I mentioned before, there should be a transition plan for high school. So following an identification, the school creates this IEP for an exceptional student. For example, whether they will be provided an educational assistant or whether a speech pathologist, for instance, will work with a student every week. These are things, and the range of services available are very broad, and they range quite greatly depending on the need of the student. Now, it may be the case that a family might disagree with an IPRC. Remember that, however, the interest of the child is of paramount importance and significance when coming to the determination by the committee for what the needs are of a child. But for the purposes of your understanding, a disagreement with the IPRC will require the filing of a notice of appeal with the school board saying that you disagree with this and the reasons for the disagreement. The IPRC can hold a second meeting where they'll confirm the decision or change the decision at that stage. Now, if the parents are still not satisfied, there are various appeal mechanisms available when it comes to special education. And these are a few different stages. You can go to the Special Education Appeal Tribunal, and the alternative option would be the Human Rights Tribunal if you believe that the programs and services are not accommodating your child. You should seek legal assistance for the Human Rights Tribunal, and if you are considering any appeals, you may want to get some legal support in that as well. The Special Education Appeals, the Special Education Appeal Board is a panel of 3 people who review the IPRC. Now, the school must give you at least 10 days notice before the appeal board meets. And parents and students over 16 have the right to attend and participate in that meeting. So the appeal process and the appeal options for disagreeing with an IPRC are quite extensive, really. There are a few different levels or stages that you can appeal to, all of which may require some legal support to better help you understand the processes or better support you in your legal arguments that you may want to put forward in those determinations. But when we think about special education, we really got to think about the accommodations that are in place by schools, and at what point do these accommodations at what point do these accommodations cease? At what point do schools reach what's called an undue hardship? Now, if the school provides transportation, they must accommodate a special education's, a special needs student transportation requirements. That's just an example of a way in which schools accommodate students. The schools must provide an appropriate program and services. And appropriate does not mean to have the best program or best services available anywhere. What accommodate does mean is that they must be good enough to meet the student's needs. So that's what it means by the duty to accommodate. Now, sometimes this is a difficult area to work out with the school board. The Special Education Tribunal has made it clear that finding the right placement must include some consideration of the programs and services that will be delivered. If either the parent or the student are not happy, they should speak with a principal and or the special education teacher, and they may want to speak to the superintendent in charge of special education to explain why the program is not working. Parents who do not believe the school is providing programs and services that accommodate their disability, as I mentioned before, may make a complaint to the Human Rights Tribunal. Now, the undue hardship that's placed on schools occur when there is literally nothing else that they can do in the circumstances. They've exhausted all reasonable options. They may not have the resources or the capacity or the programs available in a school or a school board to provide that. But this may still be, in schools may use the point that they've reached undue hardship or they've exhausted all options. As an advocate, you really want to challenge that and make sure it is in fact the case that they have exhausted all options. They have made use of everything that is available at their disposal to try to accommodate a student. Now, shifting gears a little bit, when we talk about special education, we also unfortunately have to talk about student discipline. Now, there has been some case law that has supported students with special needs as it relates to discipline. The Human Rights Tribunal a few years ago found that there was a systemic disproportionate impact on students who experience disabilities or receive special education. There's a disproportionate amount of them who are disciplined. Now, if a student's actions are the result of a disability, then the school has a legal obligation to accommodate the disability before disciplinary action. If the school has accommodated the student's disability to the point of it causing an undue hardship to the school board, then the student can be disciplined for misconduct. Again, you really want to challenge this idea of undue hardship if it's ever raised. You want to ensure that a school has in fact exhausted all of its options before they're able to make that position clear. Now, when it comes to advocacy for students with special needs, you are your child's best advocate. And that means you are the person who a child needs to be the starting point for having these conversations. Students need a caring adult to ask the important questions, get the important people involved. So so for parents who may feel that a lot of this information is simply overwhelming, it can definitely be very difficult and onerous to sift through all the rules and different ways in which you can advocate. The important thing is that you are taking the steps necessary to draw and raise attention to these issues. There are plenty of supports that may be able to better your understanding or even be there as a third party to give you that advocacy support that you need. The human rights process is available if you are thinking about involving more legal channels to protect your child's rights. And where there is an apparent violation of a student's human rights, either due to a failure to provide accommodations or otherwise, the Human Rights Tribunal may be a good option for that. There are a few resources available on the Ontario Human Rights Tribunal website, and you will be able to find more information about how that process works. But in terms of the resources that can better help you right now kind of navigate the special education issues that you may have, you may want to look into resources available at the Ministry of Education through their website, contacting legal clinics such as Justice for Children and Youth, or the Pro Bono Law Ontario Education section. You also may want to consult with a lawyer who's familiar with these issues so that you can best be aware of your rights, the next steps for advocacy, and how best to support your child in circumstances. That was the conversation on special education. Our goal again was to help kind of erase the stigma for what preconceived ideas of special education are, but also to help you understand the process and ways in which you can use it to better support your child. So with that said, to stay tuned for our other videos, check out the other topics that we discussed, such as student discipline, bullying, harassment, and just understanding the education system. Thank you.